The time after the death of a close friend or family member is hard enough without having to deal with uncertainty and delays that often accompany transferring the assets of those who have passed on. Small estate affidavits may be able to help you avoid these. We're eForms, the largest online database of fillable legal forms. In this video, we'll discuss Idaho small estate affidavits, including how they can help speed up asset transfers, the eligibility requirements for small estate affidavits, and the process of crafting and using the affidavits. And if you're looking for an official small estate affidavit that meets the specific requirements of Idaho law, watch through to the end of this video where you'll find a link to create your own document. First, how can small estate affidavits help? Small estate affidavits are legal documents in which someone, typically called an affiant, declares that he or she is entitled to property that once belonged to a person who has died. Once completed, the affidavits provide the holder with a right to collect the property. In legal terms, a person who has died is called a decedent. The property the decedent has left behind is called the estate, and the process of distributing that property is known as probate. For some estates, probate can be a long and complicated process because there are disputes about who is entitled to what. As you might expect, these disagreements are more common when the value of an estate is large. But because small estates are typically much simpler to distribute, most states allow people to use the affidavit process to speed things up. What are the eligibility requirements for small estates in Idaho? Only estates with a total value of less than $100,000 are eligible for the small estate process in Idaho. However, the amount can include personal property as well as bank accounts, stocks, and bonds. Idaho also requires that there are no other pending applications to use a different process to distribute the estate. You may hear of these referred to as appointment for personal representative, and you can find out whether there is such an application by checking with the local probate court in the county where the decedent was living. If a small estate could be of use to you and the estate is eligible, what is the process for collecting assets? First, it's important to know that Idaho imposes a waiting period of 30 days before the small estate affidavit can be filed. It's a good idea to keep a copy of the decedent's death certificate to demonstrate the decedent's date of death. During the 30 days, you should determine whether the decedent has a will. If there is a will, the people entitled to receive property under it are called beneficiaries. If there is no will, a small estate affidavit can still be used. Idaho laws will determine who are the successors or heirs that receive property. Usually it will be a surviving spouse, children, or parents. In Idaho, only beneficiaries and successors may use the small estate affidavit. Fill out the small estate affidavit form and sign it in the presence of a notary. Keep in mind that Idaho requires a separate form for transferring vehicles. A link to this form is available in the expandable section below. Once the affidavit is ready, you can present it to someone holding property that you have a right to under the will or Idaho succession rules, and the person is legally obligated to surrender the property. To find an official Idaho small estate affidavit form that you can customize to your situation, click here. And don't forget to subscribe to get other eForms videos about legal topics that you can use in everyday life.